Fergal Gaynor, the lawyer representing the 20,000 victims in the Kenyatta case at the ICC, was responding to the prosecutor's request to adjourn the case for 3 months in order to conduct further investigations to strengthen the case, which she felt could no longer satisfy the evidentiary threshold required at trial. In his response, Gaynor argues President Uhuru Kenyatta himself is frustrating the prosecutor's efforts to access vital evidence against him. The government of Kenya is under the direct control of the accused, Gaynor says. The same accused who, as president, is constitutionally obliged to ensure government's cooperation with the court, including the prosecution's access to all relevant individuals and documentary evidence in Kenya. And so, according to the victim's lawyer, it follows that any failure of Kenya to fulfill its obligations under the Rome Statute, including any obstruction of access to relevant witnesses and documentary evidence, must be attributed to the President of Kenya. The government of Kenya's position, Gaynor observes, is that if it provides to the prosecution any material which might be used in evidence against the accused at trial, it is violating the accused's constitutional rights. He says, quote, "This startling admission goes to the heart of the reason why the prosecution does not have the evidence that it needs in this case, because the government of Kenya has deliberately not facilitated access to that evidence." End of quote.
In all the cases that I'm dealing with, cooperation with the Kenyan authorities has been the most difficult.
The victim's lawyer also wants the chamber to take note of Kenyatta's hand in the high-level campaign to terminate the case against him, which included the government seeking and securing debates before the African Union, the United Nations Security Council, and the Assembly of State Parties.
We are not talking about immunities to shield an individual. We're talking of immunities to guarantee the continuity of the state as a state.
Despite the prosecution's frustrations, Gaynor believes Bensouda has not done enough to hold the government of Kenya accountable for its failure to permit the prosecution to access relevant evidence in Kenya. He wants the trial chamber to put her to task to explain the extent to which the government of Kenya's non-cooperation has prevented her team from collecting documentary evidence. He says, and I quote, "It would be unreasonable to permit the accused to benefit from deliberate obstruction of access to evidence by a government under his direct control." Gaynor argues that withdrawal of charges in such circumstances would create a damaging precedent for the court. But of serious concern to the victim's lawyer is that failure to prosecute Kenyatta might well impede the reconciliation process in Kenya, as ICC will be holding a trial dealing only with crimes committed against the largely Kikuyu victims in the Ruto and Sang case, ignoring the crimes committed against the largely Luo, Luya, Kalenjin and Kisii victims of this case. Meanwhile, judges trying Deputy President William Ruto at The Hague have scheduled a status conference tomorrow ahead of Thursday's commencement of trial. The conference aims to discuss the request made by Ruto to be excused from attending all trial hearing sessions to enable him carry out his responsibilities as the deputy president. Ruto will, however, not travel to The Hague tomorrow as expected because President Kenyatta has traveled to Angola. Sylvia Chebet, Citizen Live at 9.